today's guest speaker, Mr. Vivek, and Dr. Egil Kishore, the Dean, ICFI Law School, and Mr. Sunil Kumar, and my colleagues and the students. And it's a great honor to us that today Mr. Vivek is there with us to talk on the advocacy of the workshop which is conducted by ICFI Law School. So before starting, just I wanted to inform Mr. Vivek that 2 days back we got the Times Higher Education rankings, and in the world, I think we have participated, and out of 50 participation from India, our ICFI Dehradun ranked the 45th. Especially in the innovation, industry, and infrastructure, we have ranked 19 in the country. And in the world, we have ranked between 600 to 800. Because as you know, that the Times Higher Education ranking is the prestigious ranking in the world. I think we have participated first time, and we are in the progression level. I think we got this news day before yesterday. They have declared the news. With this, I think I will ask Sunil Kumar to take forward, please.
Thank you very much, sir. Thanks a lot, sir. Good morning, one and all. I am Sunil Kumar, working as an assistant professor. I welcome from core of my heart our guest Vivek Sharma, Dean Faculty of Law, Professor Yugal Kishore sir, and our Honorable Vice Chancellor sir, who is always motivating us for and encouraging us to organize time and again such events. So with sir, hope that all of you are quite well and taking utmost care of yourself and all your near and dear ones in this pandemic period. We are not resting on our laurels and striving hard to achieve all our desired objectives for imparting best legal education. This workshop is an exiguous endeavor and a step towards bridging the gap between theory and practice. Friends, advocacy is an art gained out of experience during various phases of practice. Today, we have with us the gems of this profession who have a lot of experience in the field of advocacy, and I hope all of you would learn and enrich your knowledge by the experience shared by advices imparted by our learned guest speakers. Friends, what I found in this 22 years of my career in this legal arena, I have experience in diverse fields of law, including 8 years of practice in civil and criminal side at district court. I found that the good brains, they are more prone towards either judicial services examination, or they prefer to go to corporate sectors where they can make quick and easy money. But today, the speakers with us, because I have gone through and I know them personally about their life, they are the live examples where they have strived hard, worked hard, and achieved this stature where they are one among the jurists in India. So this is my advice out of experience. to all young budding lawyers on the platform and off the platform, that in fact this profession of law is losing its sheen, not because that we are lacking the brains, that we are not hardworking, that we are not giving good trainings, but because we are losing our interest in this profession, in this particular side of profession, means practice of law. And this is a reason at the grassroots level, what I found, that there is a lot of corruption brooding day by day. The young lawyers, they were just going for such means which are professionally and ethically not good to flourish their practice. So this workshop was organized with the object not only to hone up the advocacy skills among my pupils, but the pupils, young budding lawyers pan India. I hope that I am taking much time of my learned speakers, because I am, by profession, I am a teacher, and we have a practice, and we love to talk to our students. So with this, I hand over this session to our learned Dean, Professor Yugal Kishore, who have been a lot of experience in these fields of law, who have been earlier a Vice Chancellor of one of the in several reputed universities. And definitely, he is always a guiding spirit and a motivating spirit for all of us to give our best. Over to respected Dean, sir.
Namaskar, sir. Namaskar to everyone. Good morning to everyone. Respected Honorable Vice Chancellor Sahab, Professor Dr. Muddu Vinay ji, very learned, experienced, skilled, the speaker of the day, Mr. Kundan Mishra ji, Mr. Vivek Sharma ji. If दोनों नंबरों में मैंने गलत कर दिया हो तो प्लीज क्षमा कीजिएगा. उसके बाद the organizers, Mr. Sunil Kumar and Miss Prachi, my esteemed academicians, professionals from different universities, and my dear student friends. You know that university has been catering and imparting the knowledge and skill in the core areas through innovative education programs, research and development. And thereby, it has developed a new cadre of professionals with high degree of competence and deep sense of ethics and commitment. It has resulted that university was ranked last year as URI 44, World University with Real Impact 44 by the United Nations Institute of Training and Research in 2020. Just as our Honorable Vice Chancellor has informed you that we are proud also that one of the most prestigious award ranking organization for higher education in the world, the Time Higher Education World Impact Ranking to ICFI University has been 45 this year. So we are proud of that, and the credit goes to our very learned, experienced and motivating, inspiring Vice Chancellor Sahab for this. Further, ICFI Law School, Dehradun has been imparting various professional skills through workshops and training to the student. You have seen last year, my dear friend and faculty, Mr. Sunil Kumar, with the assistance of other faculties, have organized a number of workshops, training programs, and intra-competition to develop the professional skill in you. This year again, a number of workshops have already been organized in the field of art of advocacy, crime scene investigation. Today, we are, Iqbal High School is conducting the national workshop on art of advocacy and nuance of trial advocacy. The art of advocacy, if you look at, it's a very wide topic which consists of many professional skills of an advocate. That is communication skill, drafting skill, articulation skill, listening skill, courtroom etiquettes, horizontal and vertical relationship in advocacy, time management, stress management, team management skills, and research skill, along with technological management skill. And the most important, the trial advocacy skill. So today, we are very fortunate that we have with us two very learned senior advocates who will be imparting knowledge and in the field of, not only the field of trial advocacy, but the most important aspect which is there, that is the whole of advocacy. So with this, I am very much grateful to both the learned great speakers of the day, Mr. Vivek Sharma ji and Kundan Mishra ji, that they have spared their valuable time. I'm told that our Vivek Narayan Sahab is suffering today from ailments, but even then, he has been so kind enough to us that he is here to enlighten, to motivate, to inspire, to train our students. So with this, I wholeheartedly welcome Mr. Vivek Narayan ji, and thank you very much that you have been a great, you are doing a great job to our students and to the whole legal professional fraternity. Further, we have Mr. Kundan Mishra ji also. He will also be imparting training, and he is here with us. I on behalf of Iqbal High School, the organizers of this program, and my student community, wholeheartedly welcome you and thank you that you have spared your valuable time for this particular program. I'm sure that after this workshop is completed successfully, my students, not only my students from all over India, those who are participating, will be having a great knowledge and skill in the field of advocacy as well as trial advocacy, so that tomorrow, when they go to the court, they will succeed in their field. And that is what our motto is. So with this, I thank the organizers that they have been organizing it, and I thank the speakers that they are here. And above all, I thank my Vice Chancellor Sahab that who has spared his valuable time to inaugurate and bless us. And then I thank everyone. With this, I go back to our Mr. Sunil Kumar ji and Prachi Madam.
So,
thank you.
Thank you, sir. Thank you, Yugal sir, for such a kind words. So, Shruti, are you there? Shruti?
Yes, sir, I'm here.
So, Shruti, let us begin with the program.
Yes, sir, sure.
Over to you.
Thank you, Sunil, sir, for giving us an overview of this session. Now, moving forward, let me introduce to everyone to our first keynote speaker, Mr. Vivek Narayan Sharma. Mr. Vivek Narayan Sharma is a socio-political constitution expert and renowned advocate and strategist practicing at the Supreme Court of India. Despite being the first-generation lawyer, he has made his place in the legal fraternity and is the heartthrob of the legal profession. He is the elected Joint Secretary of the Supreme Court Advocates on Record Association. He assumes pro bono legal activism to improve the spectrum of the society. He has provided pro bono legal service to marginalized women fighting against crimes, armed forces personnel, paramilitary personnel, and jail convicts. There are many known PILs in his name relating to Ganga Action Plan, Nirbhaya case, illegal electricity bill water waiver, home buyer, Johnson & Johnson, faulty hip replacement, demonetization, halala, and polygamy, and others. He is the president of Society for Criminal Justice and national advisor, consultant and convener for eminent social political outfits and law journals in India. He regularly speaks at seminars and events with the voice of motivation and positivity, apart from strengthening everyone's legal acumen. He is India's chapter advisor to Indo-Canada Chamber de Commerce. He is one of the most popular, most discussed, and most read columnists for Times of India and Economic Times. He has authored Electronomics, a book published by the world's top publishers, Thomson Reuters. Over to you, sir.
Very good evening to all. Very good morning to all of you. Great thanks to the ICFAI University for inviting me for today's keynote lecture. Great thanks to Mr. Muthu Vijay, the Vice Chancellor of the University, Dr. Yugal Kishore, Dean Law Faculty, Ms. Prachi Mishra, Professor, and Mr. Sunil Kumar, Assistant Professor of the University. My great regards to Mr. Kundan Mishra, who is my co-speaker today. So it's always great for me to connect with the youth, and we find youth in the universities, and therefore I am always interested. I am undergoing COVID treatment. My entire family is undergoing COVID treatment, but somehow I thought that I would not miss it, because there is always something to communicate to the youth who inherit the best quality of idealism. And when the youth are given right direction, then by virtue of that right direction, they can become asset instead of become liability. As Mr. Sunil Kumar had earlier said, that he was really not very happy about seeing certain kinds of practice. Even the youths are indulge in some kinds of practice at trial courts which are unethical. So of course, means these are those things because of the lack of guidance and various problems that they may have in their life, that they start using wrong ways of life. So while the art of advocacy is a wonderful subject to talk about, and when we talk about the art of advocacy, so first we need to understand what is advocacy. But before that, there is a slight correction. As I was, with regard to me, I was told that I am the Joint Secretary of Supreme Court AOR Association. I used to be, now I am not. I have completed my tenure last year. So that's a small correction I wanted to make. So when we talk about the advocacy is an art or is a profession. People may have different versions, different views with regard to this aspect. What does a lawyer do? What is the best thing a lawyer can do? Lawyer can give friction to the mind. It can churn the ideas, the strategies. What is the best we are doing? What do we achieve by doing what we do? We do it for the benefit of society, for the people who are there. There are different kinds of benefits which we draw, like for the personal benefit, in the sense that two parties are fighting inter se, so therefore we are representing one party, or the other party is being represented by other counsel, so we are strategizing for the one party. Then there are other this is a contentious litigation part. Then there is non-contentious, where two parties want to join some arrangement together, want to do some business together. So therefore, you devise a mechanism for them that they are able to do the business in the most easy and fluidic manner. And how do you do that? By carving out the agreement between them so that there is no question of doubt as to what are the obligations and rights of each party. Then there are other portions, means government interfaces there, government employs advocates in their panel, government employs in their services. Similarly, there are private corporate services. So there are various types of advocacies, if you look at it. So which one can really do? People are there, very good drafting councils. They only draft, means that they specialize in draftings. Then there are arguing councils. They specialize in arguing. Then people are who are become solicitors, who do not argue, but they are good solicitors to the extent that they are able to brief the senior counsels, tell them what is in the matter and what has to be argued, and then accordingly the senior counsel lead the matter and then argue. So there are various origins within the field itself. So when we talk about advocacy, advocacy is a very big field. People go into academics, people go in writings, and then there are so many other avenues within the field. So when we would talk about advocacy today, means I would be mostly concentrating on the litigation part of advocacy, where we mostly in the Supreme Court and then trial means mostly of the appellate advocacy. So when we talk about the appellate advocacy, means there are of course means certain sets of tangents which you have to follow. Like one is preparation, the other is tact, the third is respect, and the fourth is honesty. So when we talk about the preparation means it can be a general preparation, which you do every day, like grooming yourself for the profession, grooming yourself for the getting ready for yourself for every day. And then there is going to be a specific preparation when there is a specific case which you have, then with regard to that case, you have to do that specific preparation. So when we talk about general preparation, what is that general preparation? It is just like every day you get up in the morning, you sleep before that, and after that you brush yourself, you take bath, you do daily chores. Maybe some people pray, some people meditate. Various kinds of chores are there which are to be performed every day. So similarly, in an advocate's life, there are certain chores which are required to be performed so that a person could become a good advocate. And what are those? Like reading is a very inherent and inbuilt skill which is required to be generated within the mind, within the set of advocates who want to do good in their life. So reading every day, reading, not confined to only legal books, not confined to only case laws, not confined to only the legal subjects, but reading in general. Because advocate, you must understand the idea of being advocate, which is advocate can be a lawyer, can represent any person of the society. A person can be scientist, a person can be doctor, a person can be engineer, a person can be professor, university, blah, 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 means n number of things. Every person may have some litigation. So therefore, you do not know who would be your client, who is your prospective client. So therefore, reading in wide variety of subjects would always entail great knowledge, insight knowledge into you, and which will in turn help you garner the clients when they come to you. You would be able to have those basic knowledge pertaining to that subject, and therefore having wide variety of knowledge in different aspects of life is very critical and important to become a very good advocate. That's one part. Then we talk about when you are able to read, then the second part comes that you are able to speak as well. And then the speech practice is something which becomes inherent. So whether you want to become an arguing counsel or not, though everybody aspires to become an arguing counsel, but then there are various difficulties. People become claustrophobic. They are not able to, they stop getting ideas when they go before the dais, before the judges. So there are various kinds of problems that may occur with the individual, but then those problems can be mitigated by way of practice. So what are the kinds of practice that you are required to do? Speech practice is one of that every day you are making some speech, making some practice by way of reading, maybe reading a newspaper in a loud manner so that you are able to deliver in your own voice. Today means my voice is not very good. I'm a little coarse and not because of the corona. My throat is, it means it is only the 60-70% effective. So, but at the same time, that meditation, I do meditation, perform meditation every day. So this is really able, means helping me. So when you talk about the speech, when you prepare yourself to speak, then practice, everyday practice in a methodical manner will always help you. So that's another aspect. And third thing is that when you come in the profession, there is a lot of stress, a lot of work to do. And then the stress is qua work also, stresses of that also that there is no work. So that you have to garner work, you have to think, because in the profession you cannot go to people and say, ask the work from them. So you have to wait that people should come to you. And it comes with the reference only, that somebody knows you who has for whom you have done good work. So that person in turn will tell see, you consult this expert advocate, he is very good in that. So therefore the work comes only through references. So the stress has to be mitigated. You have to keep yourself positive. And I find my best way is meditation and concentration practice. That really helps in mitigating that stress and keeping me positive and in equilibrium. Then the fourth very elementary aspect is fit body keeps fit mind. So keeping your body in a fit shape is essential, necessary. Some people may go to gym, some people may go for walk, some people may do yoga or other stretches exercises, or some people may play tennis or some golf or some other sports. So whatever it is, whatever you like, keep 30 to 40 minutes at least every day for yourself, where you are doing something to your body, not thinking about anything else except working out the way you want. If you are walking, walk brisk, be fast. If you run, okay, contain your run in such a manner that you are in a method that you are able to run every day. So whatever you are doing, at least keep this habit. Means if you are not able to do it every day, at least keep this habit of 3 to 4 days of a good routine, fitness routine in your life, so that means there is no difficulty of your mind and body that you will confront. So you will be fitter side will get good ideas. The work which somebody may complete in 2 hours time with fit body, fit mind, you can complete that piece of work maybe in 15 minutes, in 30 minutes, and this happens. So keeping yourself easy, in good shape, keeping your mind and your equilibrium in good conscience, practicing every day what is required to be done. These are the basic elementary, just like we sleep and get up, we brush. Similarly, these are the things which are required for an advocate as well. So now we come to the other part. Now we come to the tact part. This is the preparation of being an advocate. When we talk about the tact, then how do you develop the tacts? For tact to develop, it is very important that you inherit that necessary information, that necessary knowledge that is pertaining to the subject matter. Subject matter is wide. Means if suppose you are practicing in any area of law, you are not required to be restricted in that. A client may come, can say, sir, I want you to represent me in this matter which is pertaining to different area. So therefore, so how would you develop the tact pertaining to that matter which has come to you? So it is the inherent knowledge that you have garnered, you have generated within yourself, due to which you can develop that. So therefore, there is a preceding thing which would precede before the tact, and that is the garnering that inherent knowledge of different subjects, different legal subjects. So for that, I had employed in my own life a particular way. I used to read every day 3 to 5 judgments of Supreme Court every day in the morning. So when I used to get up at 5 o'clock in the morning, I used to read these 3 judgments from the very beginning. So this used to help me in mitigate the future circumstances. How does it happen? It is very simple. When you are reading those judgments, 3 to 5 judgments every day of Supreme Courts, in a month's time, you have read 90 to 150 judgments. So it's considering that on an average, I read 4 judgments. So 120 judgments of Supreme Court I read in a month. So therefore, when we multiply it to 12 months, so you see thousands of judgments have been read by me in a given year. And these 1,000 judgments would be pertaining to different subjects. Varied aspects on a particular subject would also be covered, and also different subjects would be covered in a very good manner. So therefore, when I'm talking about reading the judgment, it is not merely reading. So what I used to do when I am reading the judgment, so I will always cull down what is the issue involved and what is the observation given by the Supreme Court. So that's the simplest way in the shortest period of time that one can read through judgments. There are judgments which may run through 100 pages or into 1,000 pages. There are judgments which may run through only 10 pages. So it is the art of reading those judgments as to how to read when you are preparing yourself to develop your own tact. So that art of reading judgment is very important, so that you are not putting the entire day in reading those 5 judgments, because this is the preparation for the future. You are preparing yourself for the future. So what to do? So just find out the issues involved. I think there is somebody speaking. Yeah, thank you. So when we are talking about the reading judgment, so very slim in paragraph number 2 or 3, usually there is a factual background which is confined to necessary factual facts, and thereafter you find what are the issue involved in the matter, which is usually in para 1 or para 4-5, and then you go for finding when the arguments of parties complete, means argument from the petitioner side, from the respondent side complete. And then there is a line which starts, okay, we have gone through the argument, or we have heard both the parties. So therefore, the court start analyzing the propositions given by both the parties on the subject issues. So we skip that part also. We come to the conclusion part. Okay, these were the issues involved. This is what the court has found, given the finding. So that finding has to be found out in the last paragraphs of that judgment. And usually, if suppose there are some styles of judgment where you will find that the findings of different issues are contained in different places of the judgment. So this is the way that one has to find out as to where the findings are there on the issue. So what is required to be done is small factual background, issues, and the finding on the issues. So once these 3 things are done, you make your own short note. So I used to make my own short note so that it is ready and handy with me. Okay, in such and such a judgment, this was held. So this kind of attitude and preparation will help you in developing your tact for the future, because you would know, and it would be ready with you, that as to what has been held by the Supreme Court in such and such matter. And then those things can be applied when any client comes to you in any situation. You can apply those judgments, and you would be able to know what has to be done, what is the right approach, what I should advise to my client. And it so happens, means it really helps you greatly. I must tell you one example, means it pays very greatly. Such preparation, that back in I started my practice in 99, and this was in 2001, that in one of the party, one senior person confronted me, and they were talking about a very big matter which was going in Supreme Court. So the matter was filed in Supreme Court in 98, and this was 2001 December, and then he was discussing with me what can be done in this matter. So I suggested, okay, if this is the status of matter, then I think these XYZ, these 3 things should be done in the matter, and if these are not done, then I think your matter is not in the right direction. So he immediately connected his superior, And then the superior talked to me on phone, and thereafter then we connected. He said, sir, if suppose you can deliver what you are saying, it can happen, then certainly we would like you to have this matter. And this was a very big matter. So therefore, that matter was taken from somebody very senior person and was delivered to me. And though I was only having 2 years of practice, so I had charged big fee in that matter. Nonetheless, I performed very nicely in that matter. So the point is only this, that by way of sheer preparation that we have, developing those tacts which are required for the profession, that people are going to take you for your face value. People are going to take you for the kind of suggestions that you are going to make. But then how do you make them? You make them on an informed basis. What is the law? What is the subject matter? What is the knowledge that you have generated on that subject matter? So this is very, very important. So developing tact is very important with regard to the court, client, and opposite counsels. And at the same time, in the center of all this is the knowledge, sheer knowledge of the subject matter that you can generate over the year, over the time, when even you don't have the case. So this is the best time to prepare, when you don't have a case. So prepare as if some case is going to come, and you have to tell your client. So if you work with that attitude, then certainly you will be able to retain the knowledge that you are garnering. So it is one thing that I am reading 100 things. It is another thing that how many I am able to retain, and how many I am able to assimilate in me, that I am able to understand and explain to the other. So understanding is one aspect, and explaining the same thing to the other person is another aspect. So you have to be master on those things, and that's how you develop your tact. Third very important aspect is respect. Respect, of course, for the judiciary, judges, your own peers, colleagues, clients, everybody. Means a lawyer is required to have a respectful attitude. It is very, very important, because if you will give respect, you will be able to command respect also. And that's how you really make the profession very healthy. And another important aspect is honesty. And honesty is best performed before the court, because you cannot conceal anything from the court. If you conceal, it would be at the cost of your own reputation. You will lose your sheen. You will lose your faith on you inside the court, because the court would know that you are such and such person. And therefore, it is very, very important, especially in appellate practice, where the judges are very less, and arguing counsels are numbered. So therefore, any wrong deed would be paid for very badly, very, very dearly. So therefore, it is very, very important that you are always honest. Do not conceal anything from the court. Be always honest and upright. Whatever it is there in your brief, do not shy away in telling. It is another thing that strategically I don't have to say anything, but whenever you are confronted anything for speaking the right thing, then you have to speak right. Number two, something which is important to tell. Always tell. Maybe it might be possible that it may go against you, but it is important. Sometimes it so happens that the courts are very mesmerized with the fact that you have been candid and open and honest in telling the truth. So therefore, they start giving you relief. So good behavior, honest behavior really pays very well in the long term of practice, and it also creates a very good reputation for an individual. So these are, some necessary steps which are required. I always believe in one more thing, that always keep the sleeves of your strategies down. Always keep the sleeves of your strategies down. That means even your office should not know what all strategies you have in your mind. There is always something surprising or maybe shocking for the other party or the other counsel or even your own juniors that you are keeping. You have something up your sleeve. That element of surprise should always be there. And once that element of surprise is there, people will have to wait as to what you are going to do. And that surprise element, that element of abeyance, non-knowledge, will give you an edge over your opponent. So this is something, means, of course, this is another thing that has to be generated within yourself. So these are the advocacies, various advocacy is not merely confined to these aspects. There are many, many more aspects. Means I'm not able to speak too much today. My throat is a little bad. So therefore, it would be great to interact with you, the guys, another time as well. So with all this, I would just leave, and if suppose there are some questions to be asked, so it would be my pleasure to respond to them.
Thank you, sir, for making us aware of the nuances and technicalities of the advocacy. So with your permission, can we start with the question answer round, as there are a few questions we have received from the participants related to this session?
Yes, please.
Yes, sir, sure. So the first question is, how to contradict a witness on questions to facts when you possibly know that their testimony is concocted?
This is trial advocacy, means when you're talking about that, I did not speak about the trial advocacy, and I think Mr. Kundan Mishra must be talking about it. So as I'm not covering the subject today, so therefore Mr. Kundan Mishra will be the best person to really talk about it. But it's still, when when somebody has asked me this, when you know that the witness is tutored and it so happened, but at the same time, means I'm going to give you my own strategy. I've never lost a trial till date, and I have been always able to extract whatever necessary information is required for me from the cross-examination box. So it is always very important that you know that the witness which is standing opposing you is going to lie, and it is not going to give what you want to have in support of your matter. So therefore, what happens? Have patience, have smile, make the witness feel comfortable. Know that you know, don't allow him to know that you know he's lying. Be positive. Your positive assertions will make the witness easy, and once the witness will be easy, so then it will start delivering you what you want. So making till the time that defense guard of the witness is on, witness will not give you what you want. But when the defense guard would be down, it is your best chance to bring what you want. So next question.
Yes, sir. So the next question is the most asked question is, if a law graduate wants to pursue advocacy or litigation, what should be the right approach for moving forward in this direction?
You have to understand what are your core strength areas. When you are able to judge your own strength areas, then think about going in that direction. Some people are very good in speech, in arguments, and then some people are very good in strategies. Some people are very good in research work. In today's time, research is altogether a different aspect, because judges are employing researchers within their chambers. So depending what is your strength area and what do you want, but more or less in the beginning 5 years, you can do anything and everything. And thereafter, you can devise a way that what would be your best time forward. So it would depend on each individual's own great skill areas.
Thank you so much, sir. Now, a very special thank you to you, sir, that despite having this undergoing treatment of COVID-19, you are here to bestow your knowledge and impart the skills which a student or the participants need during this advocacy rounds. Thank you so much. Thank you so much, sir.
Pleasure connecting. Thank you so much. It means please allow me to disconnect for the time being. I will take some rest. Thank you so much. I will miss Mr. Kundan Mishra's address, but I'm so sorry. Means I'm having a little headache because of the speech.
Okay, sir. Thank you so much, sir. Stay healthy, sir, and please take care of yourself.
Thank you, Vivek, sir. Thank you very much. for being here with us in spite of your health issues, because in fact this is very encouraging for personally for me, and definitely for all those hundred of students pan India who are the scholars of law who are present on this platform, which this shows that how the lawyers must be strong to face every kind, how the lawyers should prepare themselves to face any kind of hurdles uh, in the profession. Thank you, sir. Thank you very much for being with us. Get well soon, sir. Thank you, sir. So, Shruti, over to you, Shruti.
Yes, sir. Thank you, sir. Our second keynote speaker is none other than Mr. Kundan Mishra. He is advocate on record of Supreme Court of India. He had completed his LLB from Campus Law Center in 2004 and appeared for Bihar Judiciary Service and qualified, but due to his love and passion towards practicing law, he left and started practicing with his elder brother in Patna High Court. Later on, in 2007, he moved to Delhi and joined Tees Hazari Court, and later on, he started to get cases from High Court and Supreme Court. Finally, in December 2010, he became the advocate on record of Supreme Court. He is now partner at Kundan Mishra and Satya Mishra Law Court offices, Delhi. He is a member of the Honorable Society of the Middle Temple, England, and dealt a lot of cases in tribunals there. He had also worked as attorney of law in the Republic of Seychelles, and he has joined Bar of the Republic of Seychelles. His favorite subject is comparative constitutional law and comparative commercial law. Welcome to the workshop of the advocacy, sir. Over to you.
Thank you, Shruti. Vice Chancellor, sir, Dean, sir, learned professors, and my very good friends. A lovely morning today. I'm really enthralled every time when I get opportunity to talk to my friends. I really became, it gives me the highest level of delight when I get opportunity to interact to learned professors. And I feel a bit jealous when I see that they are still reading law and they are still imparting their knowledge to others, whereas we are mostly catering a person who actually can come only to us. So thank you to all of you to provide me this opportunity to deal with some very core area of this advocacy. I would like to now as we have seen that my learned friend, Vivek ji has gone through the appellate court advocacy, and he has very nicely elaborated various aspects of human life also, that how we should conduct on a day-to-day basis. Because advocacy is not something that can be learned or that can be practiced only inside court or while sitting on a table. It's not written anywhere in a book that we can pick up and start reading and learn something. It is something, a kind of way of life. So we have to learn it bit by bit. It is incremental. It cannot happen overnight. It will take time. And obviously it will come by experience and with interaction. And by going through this process in a systematic manner on a day-to-day basis. I always believe that the preparation to become a good advocate and to develop the skill of an accurate advocacy begins from the very first day when we enter into the law faculty. What I personally feel that actually University of Law is basically a university of life. When I use this word that why University of Law is actually University of Life is basically, I derive my thoughts from the idea that when we are into the University of Law, we learn the various aspects of human behavior. It's not that we learn only what is written in a textbook, but those textbooks of law are actually based upon the human behavior.
The criminal law is actually the same thing. That all deals with the guilty mind. Actus reus cannot become punishable. The reus cannot become, actus cannot become reus unless mens is rea. So the guilty mind, guilty conduct, etc. This all comes from the human behavior. Even our constitution is an excellent example and document of human behavior and how a human conduct themselves in a society by organizing themselves in a different institution, which have given a sanction in a supreme document so that there shouldn't be any confusion across the country. Coming back to the basics of advocacy, there is a finer difference between advocacy when we practice in a trial court and the advocacy when we see at the appellate stage. Those finer distinctions are because of the forum that we are dealing it with. The trial court advocacy laid the foundation of entire advocacy. The reason is that is the first occasion where you are preparing something, where you are putting up your case. It will be extremely difficult to expound on it if you miss something, and it will be extremely difficult to cover those facts in appellate stage if you miss some vital points at the very first stage. What appellate stage we can build upon it is to hone all arguments, to sharpen it properly, to make issues out of the same pleadings in a very nice or maybe more delicate way. We can cite some laws because, of course, there is a presumption of law. Even we don't plead law, it is presumed to be pleaded. But the point is that the most important thing is the pleading at a trial court level, at an entry level, which is going to create foundation till the end the matter is finally settled and decided by Supreme Court. I will directly would like to take our friends to some basic parameters which we must keep in mind when we go into the preparation of draft pleading and its different and its various structures at different level. For example, the advocacy begins when we make our suit plaint, when we draft our application, and we file it. That is the very first step that we do. When a client comes to us, we take their case, we understand it. A client comes with you, in front of you with a jumble of facts. They don't know how to express, what to express, but they know that they have something to say. And they want to say, communicate it through you before a body which can make a difference in their life. So they come with a jumble of facts. They try to provide as much as they have. Maybe many of things are irrelevant. Some of them could have been relevant also. And the first step begins to find out what actually is the really relevant, admissible, and what is actually the true facts based upon which you can build a story. There has to be a systematic story behind every case. It has to be fluent, it has to be convincing, and of course it must be based upon the facts which you can prove inside the court, establish it in due course of time by way of some credible and cognizable evidences. Pleading a fact which we cannot substantiate can only wither away the vitality of your argument in later on. Many people think of putting their case on a very high pedestal by infusing various facts into that, which may not always be true, which may not always be, but may sound very impressive on a first blush. That can give them a temporary attention, but that temporary attention will completely be taken away when the judge will notice that actually these facts are mere bald statements, assertions of a kind which didn't have very strong backup. So be very truthful, very skillful when we plead our facts, and then we should plead our facts in such a way that the legal inference which we wanted to derive from it should be the natural consequence of it. We don't need to write every time when somebody has done arbitrary action to write that it is an arbitrary step and it is hit by Article 14 of Constitution of India. Obviously, everybody knows that if anything is arbitrary, it is hit by Article 14, it cannot stand. But how the facts have, how it is arbitrary is something which we have to establish by pleading our facts in such a way that if somebody having knowledge of law reads it, will automatically reach to the inference that yes, Here is the arbitrariness that is inherent into the facts. So the first important thing is pleading. You must plead your facts in such a way that you need not necessarily plead your law, and the pleading of law must be the natural inference of your factual pleading. So plead the fact, not the law. Plead the fact in such a way that law is the natural consequence of your pleading. And anybody who reads it understands it. I am repeating it time and again because this is the most important aspect. I would like to share my personal experience in this regard. Generally, when I see youngsters, when they try to prepare draft, maybe at appellate stage also, they try to attack upon the lower court in bit harsh manner, like judge has failed to understand, honorable court has failed to understand, somebody has failed to understand. It gives a very negative connotations. We can always choose a simpler word for that. But when you use the word, you must use, because it is the only word that should be used at that time. If I am saying that the lower court has failed to understand, I must explain that how it was completely gone out of mind of the lower court, and lower court has completely failed it, even though it was there in front of him. So don't write just that anything, just don't pick up a legal jargon just for the sake of showing that, yes, I know many things and I can explain into many ways. There is always a simpler way of speaking things. Try to pick up those simpler way. And you can always think that could there be a more simpler way of putting the same thing, and try to find out that what could be the simplest one, so that if anyone reads it, they can start from the top, come to the bottom without having any difficulty, and without giving a stress, without having frown on their forehead, that what actually he wants to say. It has to be a very simple English, ideally class 10 English. The facts of narration has to be chronologically set out in such a way that from very first line, there has to be, in my mind, if I am a judge, it must come in my mind that, oh, what message you are trying to communicate me, what and in which way you are trying to take me to. So I must understand from the very first line. So that is the art of pleading starts from the very first, art of advocacy starts from the very first thing, that is when you plead your facts in a plaint or applications and you file in the court. The second thing is you need to have proper evidence to support it, because once you file a plaint, once you file an application, the judges will be curious, unless other party has agreed the fact and there is no controversy on the facts, the judges would like to see the evidence. They would like to see your exhibits. If it is the lower court, they would like to see the evidence, and maybe they will be called into the witness box subjected to trial. If it is appellate court, they would like to see the exhibits, annexures, that what annexures are there. Is there any disputed question of fact involved? Is there something which should be decided in the lower court by way of tendering evidence, cross-examination and examination, or it's something that can be settled out only by looking on the evidence? For example, anything that is in the public record domain, which is a public record, Section 114 Evidence Act says that yes, it is admissible. So that's fine. We cannot just, we need not lead evidence onto that. For example, we need not lead evidence that Section 302 enacts punishment for murder, because it is there. It is a part of public record. So if something is not there, we need to have a very clear that my evidence has to be perfectly okay. There has to be exhibits to support my evidence. I can systematically take just to all those evidence, and that will inspire confidence at later stage, because when the judge will read your pleading, and then he will find that, yes, there are proper documents also standing in support. There is a witness ready to testify in the witness box, that will give your case a very new dimension, very strong dimension. Third important thing is delivery. How you argue your case, because now you have a fact, now you have evidence, how to present it before a judge. See, here I have a slight different approach. When you are doing a case in India, when you are doing a case in England, you have a two different strategy. When you do your cases in England especially, they allocate a systematically full time to you. For example, they assess a trial that it can go for a half day, it can go for 1 day, it can take 2 days time. a courtroom is blocked, and they allocate a proper time that you can present your case maybe in for entire 2 hours or 4 hours. So you have got a time. But in India, you don't have that luxury. Time is very scarce commodity here in court. In Supreme Court, during the miscellaneous matters day, maybe 2 minutes, 3 minutes, sometimes 5 minutes. So you need to ignite the excitement. You need to make your judges curious, but at the same time, you don't keep them lingering for the facts. So provide them issue on a very first line. If there may be a different way of presenting the case also, but what I have learned from my experience, that if you are doing a case in our Indian courts, you need to be very issue oriented and focused on your very first sentence. The very first sentence must ignite a kind of curiosity that can lead a judge to give you extra 30 seconds, and then 30 seconds you can buy them little more time to present your case. And that will come when you will practice it 100 times in your silent chambers of heart before arguing the same thing in the chambers of a judge. You can argue your case in front of yourself, within yourself, several times to make sure that this is the most relevant sentence which I can begin and which can generate a curiosity. And of course, it has to be in a most polite and humble way. Equally important is thereafter that you must prepare your skeleton arguments, written submissions. These are very necessary. Maybe there are cases which are very kind of strong cases, open and shut kind of cases. You don't need to file your written submission for that. But this practice is always encouraging. If you are crystallizing your argument in a smallest form, in a simplest manner, in a couple of pages, that makes duty of a judge who is going to read entire volume of file very easy. And obviously you will win the battle if you give a right tool and weapon in the hand of person who is actually going to stamp your arguments and to convert it into judgment in your favor, or maybe sometime it may not be, but who is going to write the judgment. So what I personally feel that there has to be a written submission also readily available in your hand, which you can file after your argument. And if the case is very ticklish and it is for final argument, you can file it beforehand also, so that judges can see that what you are arguing, how much time you are going to take, what are the points that you would be going to raise, and where you will take them by way of your written submissions. So it is equally important that when you submit something, you flag your arguments. For example, if I am arguing a matter and I am starting it that, my lord, my first argument is this, my second argument is this, my third argument, the judges will think that I don't know how many arguments he will lead, because there are other lawyers standing in the queue, and they all have equally important matter. So you have a limited time. Always think when you enter into the courtroom that this time doesn't belong to me all the way. I have a very small right onto it. There is a large number of people standing behind who are equally aggrieved, if not more than me. So flag your arguments that, my lords, in this case, I have 3 arguments to submit. The moment you start with this, it gives a picture in the mind of judge that, okay, he will only argue 3 points. And he will become ready and bit curious also that what 3 points he is going to raise. Maybe, and if these 3 points are really good, it catches attention of a judge. Believe me, you are very strong on the day. So there are few things, and then comes the witness handling. I will speak on to that later on. The first thing that I would like to share with you, when you are inside the courtroom, presenting your matter with your facts and evidence in your hand, you need to have a functional and persuasive approach towards judges. Aggressive approach is disrespectful. Passion, maybe that's good. But the passionate approach all the time, unless there is really a reason to become passionate and it is coming out from you because of the naturally, not in a planned manner, is always welcome. But what is the golden rule of advocacy when you are presenting your facts is a functional and persuasive advocacy. When I'm speaking about functional and persuasive, it has 2 parts. Functional means, if I'm a defense lawyer, I have certain functions to discharge. I can be very easily identifiable that I am a defense lawyer. If I am a public prosecutor, I must function as a public prosecutor. In both way, of course, our overriding duty is towards judge to give them a right facts, not to mislead them. But obviously, you can put up your best case in a function you are fit into, you are appointed on a given day. So far as persuasive advocacy is concerned, you are always within your legal rights to emphasize upon your point, to convey the grievances of your client before judge, because after all, your client couldn't speak, otherwise he would have argued his case in person. In India, in everywhere in the world, a person can plead their own case, but a client is coming to lawyer only because they are not in a position, they don't want to vent themselves out in a most legal and most formidable manner. That is why they are paying money to you. So we need to be very clear that we must try to take the heart of client out and to establish before judge in such a way that it contains all the quotings of law, relevance, admissibility, and it has a kind of passion which can be summarized in such a way that if you are doing a matter before judge, you must have this kind of feeling that this is the only place where I should have been. I should not have been to any other place but in front of you, the learned judge. And this is the only way that my case can be communicated to you, and that no one else would rather be saying it to you except me. So as in English bar, which is also the same rule is applicable here, they use a sentence. I would like to quote here word by word. They say that to really persuade someone, you need them to feel that there is nowhere else you would rather be, nothing else that you would rather be saying, and no one else you would rather be saying it to. We all know that justice doesn't stop at one particular desk. From a civil judge, it can go before a session judge. From there, it can go before High Court. From there, it can go to Supreme Court. There are a lot of appeals, revisions, review. Everything is there. But at a given point of time, when I'm putting my case before a judge, the judge must feel that this is the only place that the person should argue. You cannot simply challenge a court disrespectfully that, okay, fine, even I couldn't get judgment here, I have a provision of appeal upside. I can go up above, I can cite certain judgments. No, why do I waste my opportunity? So if I am standing today before the lowest rank of a judge, that is the civil judge from where the judiciary begins, I must argue that this is the end of world for me. And if today I cannot establish my case, I won't be able to establish ever. Why should I lose my case even before on a very first instance? So this feeling has to be, that is the core of persuasive diplomacy. And it has to be always in your mind when you are going inside the courtroom. I'm repeating those sentences again, that to really persuade someone, you need them to feel that there is nowhere else you would rather be, nothing else that you would rather be saying, and no one else you would rather be saying it to. The language, the words, the pleadings, the way it is done, it must inspire confidence also. Don't use, there's sometimes when we, some of the people I have noticed, in fact, nobody is perfect absolutely in this world, but generally when we try to, when we do matter before court, we try to avoid certain proverbs or expressions. For example, my lord, I think that. No, you should not think there in this way. My lord, bear with me. Kindly bear with me. Why my lord will bear with you? If I am speaking nonsense, why my lord will bear with me? If my lord, I think that this case should be decided in a certain way. Oh no, it's not about what I think. It's objectively, I have to establish that this is the only way the case should be decided. So these are the law, these are the facts, my lord, these are the issues, and this is the only way it should be decided. So you need to be very confident also. And the confidence will come, of course, if you will be 100% prepared, because I personally feel that it is 100% preparation and just 1% inspiration. So forget about inspiration, motive, and everything. That will automatically follow if you are 100% prepared. If I am thorough in a case, I may not be very beautiful, I may not be very flowery in my delivery, but I will be able to communicate. And the person who is sitting in front of me, a learned judge, would be able to grab that, yes, person has understanding of law. So we should avoid those kind of situations or such kind of words that I think, I personally feel, I personally believe in. No, this is not the things. This is good for speeches. It is not good for the arguments. You need to be very particular when you address the court. You must be also very clear how to tell the court, how to address the court. Maybe still our Bar Council of India has not taken out the how to address the honorable judges of High Court and Supreme Court. So still we follow the practice of honorable court, my lords, your lordships in this way, their lordships, your lordships, my lord, his lordship. So still this is the culture that we practice here. And I like it. It's anybody has personal choice. They can address judges very respectfully. And but I personally don't feel any difficulty in extending my submissions in a most polite and humble manner to a person who I definitely feel that is a selfless soul sitting here and working tirelessly on a very minuscule salary. And they have a only motivation to serve the country, to decide the dispute. They are not going to get any fee when they put 100 hours for any particular dispute. So they deserve the highest level of respect. We should never forget that. What is also very important thing is that the structure of your pleading, the structure of your argument. This is very important thing. When we prepare our pleading, we need to flag our pleadings all the time. For example, it shouldn't be chaotic. It has to be organized. Who are the what? For the very first paragraph should be what your case is for. For example, if it is a suit, this is a suit filed for this prayer, relief of injunction, or maybe a specific relief of enforcement of agreement. If it is a writ petition, then what is basically your prayer? That has to be encapsulated in a very first paragraph, so that when I see the first paragraph, I must know that fine, this is what he has come in front of me. Now I will become that, who is he? It should follow the second one, the petitioners. You can make a bold, small heading also, the petitioner before honorable court. And then you can explain in 4 or 5 sentences who are the petitioner, respondents before honorable court, the brief facts of the case. And the factual profile of the case must be chronological, because even you think about yourself that if you would like to read something, you would like to understand it systematically, how the things progressed, how the events have given rise to the present circumstances, present situation. So you need to have a chronology in your hand. After brief facts, you have to systematically go to the grounds, and then from grounds, prayers. So structure is very important. And even during the brief facts and during the grounds when you are dealing, try to flag it. Suppose I have a different brief facts of a different nature. For example, one incident happened in Dehradun, other incident happened in maybe Roorkee or Hardwar or Delhi. So we can flag the incidents at Dehradun, the incidents at Roorkee, the incidents at Delhi, the connection between each of them. So those headings have to be marked in such a way with such a key points that it can, even I don't read your inside a story, those headings can take me to a certain conclusion that what should be the story, because a judge reads every day hundreds of files. They are in this profession, they are habitual of reading the files, understanding the issues. So if you give them a small input, they will be very able to reach to the conclusion, and that will make their work very, very easy. So the structure is very important. Similarly, when you are presenting your matter, your structure should also be very important there. You need to be very precise with your prayer, petitioner, respondent, facts, what you want from the court, and the support of law which you have derived from the precedents. So it is very essential that you begin with the prayer and issue of your case. Don't keep judges in lurch that what ultimately you will come up with. Let them be very happy at the very first end that this is what my prayer is, this is what I'm going to pray for, and these are the basics, and here the facts and evidences and exhibits are in my hand, which is going to support my case before your lordship. This will help them. This will help you. You can use signposting all the time so that you don't keep them in lurch. I have 3 prayers. I have 3 grounds. My brief facts are these one. From para 1 to 3 encapsulate my brief facts. So it gives a mental satisfaction that you are not going to rob my day off from me. So they will be very happy there that this guy is not going to take more than 15-20 minutes. So confining yourself and then maintaining those confined time is very necessary. Try to prepare it, rehearse it at your own end before entering into the courtroom. Then comes your written submission. That has to be a kind of a key to your entire brief, because many times when we file a suit at the end of day in a trial court or even in Supreme Court, when those all files travel to Supreme Court in appeal, it becomes this thick, maybe 1 meter sometime, half meter. So you can measure these all files. It is too difficult, but a lawyer can read a fact in such a way that he can crystallize entire issue in 3-4 lines. Because it is always an issue involved in a jumble of facts. Even it is a 1 meter thick file, I am sure if you try to find out an issue, you can take out and frame it in a paragraph or 2. Not more than that. 1 page is enough to frame entire world. The whole problems of world can be framed. I have yet to see a case, the issues of which cannot be framed in 3-4 paragraphs. And then you should have, after your issue, there has to be the tests. That what is the test in this particular case is to be applied for. For example, that for example, very simple, that whether it is arbitrary or not. The test says that anything is arbitrary, it has no reasonable nexus, it has no reasonable connection with the object sought to be achieved. The twin test of arbitrariness, which was laid out in State of Bengal versus Anwar Ali Sarkar case 1953-54, is still holding the ground, at least on the twin test theory. So the point is that you can apply the test. That my lord, the test is laid down in this case that this has to happen. For example, I'm also citing another example in a commercial law. In arbitration matter, suppose once arbitration award is granted, it becomes money decree. Somebody can file an objection on certain grounds, but once objections are refused, it is enforced as a money decree. So if somebody has to appeal, they will have to file a first appeal in the natural court where the first appeal should go. Now, Order 41 Rule 5 says that the moment you file an appeal, you have to deposit 50% of the amount or amount in dispute, which is the discretion of the court. So suppose somebody filed appeal and didn't deposit that money, you can very easily argue, you can take out that test, that the test is that it will be dealt with as if a first appeal, it will be dealt with as a money decree, and it will be dealt with in accordance with Order 41 Rule 5, which is applicable for the money decree appeals. So the issues, whether he has deposited money or not, the test, Order 41 Rule 5 says that if it is first appeal, if it is a decree, money decree, there has to be 50% deposit. And then your facts, that whether he has done or has not done, whether it was exercised properly, the jurisdiction, or was not exercised properly. So it should flow, and it should flow in such a way that it must complete in maximum 3, 4, 5, 6 pages. Don't take it too long, because if your written submission has become close to your pleadings or your petition, then it will lose all its sheen and vitality. So it has to be actually written submission of a skeleton in nature. If you want to say something more, you can refer exhibit this, annexure this, para this. So somebody, and page number this. So immediately while I am reading, I can immediately go there and can see if I have a confusion. If not, I can proceed further. So try to make it the smallest possible. That should be the skeleton argument, how you should frame about. Now coming on to the witness handling, when evidence have to be tested, the evidence can only be tested by putting your witnesses into the witness box, leading them, first of all, for examination in chief, and then cross-examining them. Unfortunately, in civil matter, now the art of examination in chief has gone out of practice. Almost everywhere in the world, not only in India, also in England, in Seychelles, where maximum commercial matters are tried. we file an affidavit by way of evidence, and we just take our witness inside the courtroom and put one question, that is it the evidence prepared on your instruction? He says, yes, my lord, kindly exhibit it. So chief examination in chief gets over the moment we tender evidence by way of affidavit. But yes, the cross examination is something that has to come, because the person has to stand on each of his words which is mentioned into the evidence which we filed by way of affidavit. However, the examination in chief is still relevant in criminal side. You cannot file evidence by way of affidavit when you are into the criminal advocacy. So you have to elicit the facts from your witness. And while doing so, examination in chief is always considered to be the extreme fine, delicate art, and it is most tedious job, because you are knowing your client is knowing you. Still, you cannot coach your client ethically, and second, you cannot put him a leading question. So maybe your client missed something very important. So you have to all the way lead your client in such a way that without putting a leading question to him, you extract all facts from him which is relevant to your case. Maybe sometime the person who is very vocal in front of you in your chamber become dumb when they enter into the witness box, and they start shivering. I have seen several times in everywhere. In Seychelles also, where I have fortunate enough to handle few offshore cases, they always decide by way of trial. In those high-end cases, they conduct trial, even High Court conduct trial there. Without trial, they cannot decide those issues. So I've seen even experts started shivering when they go inside court. So you need to be very patient, very cool, very comfortable with your client, keeping his confidence always aloft, so that he should not start shaking his confidence and speak something which is take your case completely away. So you need to guide him. What is your name? What you have come from? What are the relief? You can stick with 5 W's when you lead your witness. Who, what, why, when, and then how. These are the words. If you are framing your question, it won't be considered as a leading question. For example, how would you describe this particular incident? Now, suppose what happened that there is a case that yesterday night, a dog called Bruno bit a person and gave a nasty bite. Now there is a case of claim of negligence, suppose. Now you cannot ask witness, so the Bruno dog has bitten you. No, you have to elicit these facts. What happened to you? What did it bite you? What was the name of that dog? When did the dog bit you? What happened after that? How would you describe the incident? What you were doing outside? What would have been the time approximately? So you cannot lead them, but still you have to extract those facts, because many times people forget what they have to say. They will just stand without any clue. So we need to guide them, and we can guide them with these lovely questions, framing it one fact in one go. You can't put a long question that will confuse your witness. Put a small question. What you were doing on road? What time did you reach on the road? What did you see? Then he will say, I saw a vehicle was coming. What happened then? I saw another man was coming. So what happened after that? They collided. Who was coming from left? This one was coming from left. How did you describe the way the vehicle was traveling on the road? Oh, it was traveling very speedily. Now your client has gained confidence and he will start speaking. So need to be very careful when you are leading your examination, chief, because one wrong question, that will be, judge will strike it out and will not read at the time of assessment of your fact, because it was taken out of leading question. Had it been in England, they will adjourn entire trial. If you put up a leading question, they will adjourn the trial and put all vested cost upon counsel who has actually committed this mistake, because they decide through jury system. So jury will be prejudiced. If I extracted a fact by a leading question, jury will come to know something and they will be prejudiced. Fortunately, in India, we don't have jury system. So they strike it out. Judges find out that this is a leading question by which these facts have been brought into record. They will not read it. So be very careful when you do your witness examination. And practice frame all your questions beforehand, that it shouldn't be leading. You must put your theory of the case. See, even we file a bail application, a small application, there has to be a story of everything. If I am before a court, I have not come just out of curiosity. I have come because of certain grievances. Something happened with me. And that something happened is actually a story. The story is it, and the good thing is that it is not a fiction. So it is a real story that you have come before the judge. So you must test the theories with facts. Your story will be organized, and you try to guide your witness in such a way that he elicit all facts, and at the same time he also support the legal theories. For example, how would you describe the way vehicle was traveling? When you are putting this question, you are trying to extract that he was negligent, because if somebody is not rash and negligent, you can't take them into a purview of section 304A. So you have to ask, how would you describe? How would you describe the person who was walking on the road? How would you walk? How a normal person would walk? Because how would you describe when he will say that, no, he was not walking, he was walking casually? Obviously, even a layman will say, no, he was not walking very nicely. He was on a road in a very different way. So that means the person was also negligent, not just a vehicle was negligent. So that will reduce the liability of your client when it will come for the apportionment as per the where the both parties are negligent. So these are the things that you have to keep into mind. Finally, comes the cross-examination. Cross-examination is relatively easy, but very tricky. When you are cross-examining your witness, here you are entitled to put any question under the sun. All leading question you must ask. You will find many times that the witness who is standing in the box for your cross-examination, to undergo cross-examination, is not a very honest or genuine. Many a time it happens. And he is fully prepared. He has attained a kind of mastery in standing to the and sticking to the facts, even though he is making a concoction. He will not budge many a times. You keep asking question, he will keep repeating the same thing. That will spoil the beauty of your cross-examination, because the moment you start at going into loggerhead with your witness, you are losing your respect in the eyes of judge, because judge will interject you. Judge will prompt you, oh, no, please don't behave like this. You are bullying it. You are trying to impose. You need not be. When you understand that a witness is not a friendly witness and he is lying something, all that you can do is to put your case. Remember three words. Put your case. You can directly tell. He may be declining it. You can give suggestions to that. We call in India giving suggestions. Suggestions are just like that. For example, the same hit and run case. I'm putting it to you. Suppose I said that how you were driving. Everybody will say, oh, I was driving very good. Oh, no, you were negligent. No, I was not. I was well within my speed. He's not going to concede his position. You can put up your case. When you see that he is difficult to be contradicted, he will be contradicted by facts later on. No need to prove that person is liar right away. You can simply put your case by asking clear facts to him that, Mr. A, I put it to you that you were driving negligently. He will say, no, don't worry. Your speed was excessive. No, it was not. You were not looking on your mirror and you were not looking in front of your car properly. No, it was not like that. No, you hit him deliberately and then you ran away. You were not considerate. You are not compassionate. Now I am putting my case. I know the answer to every question is no. But then judges will see that what was your suggestion? What did you put to your witness, opposite witness, when you were contradicting him? That all questions are your actually story, and that is actually your case. You need to be very clear onto that I can miss anything in this world, but when I am doing a cross-examination, I must put my case to witness. Even he's saying no, he might say anything, but then I must put my case. And then when I will argue my case, I will support it with the evidences that, my lord, he said that he was not exceeding, but see, the report of MB Act is saying, the inspector is saying that this much of damage cannot happen to a car unless it was traveling beyond 60 kilometers. Now see, the case that you put has been supported by the fact of a credible in nature, of a neutral in orientation, and that will put your case on a very high pedestal, and it will discredit that witness outrightly. And even you would have been speaking some fact, that fact, real fact, that fact will lose its sheen and its intensity. So this is how you should not be bothered about, even though a strongest witness is standing and he is not budging from his concocted position. You can explode by putting your case, and you can explode later on undermining his all witness credibility by showing the evidences and putting it in line with the case that you have put up in front of him. Of course, there are opening speeches and closing speeches that you also have to deal with. At the time of closing a speech, you have little more time. At the time of opening a speech, you have a less time. In Indian courts at lower court level, it has the opening a speech and closing a speech is more important than opening a speech. And then it depends upon the case to case also. But in a superior courts, the opening and closing a speech is phenomenal importance. You are putting your case first, then comes the counter from the side of other side, they will rebut, and then there will be a final rebuttal from your side. Your final rebuttal has to be very small, short, poignant. Your opening a speech has to be full and spreading over, taking, and you also have to do a job of introducing facts to the court. So in an appellate side, when you are opening a case, your duty is more onerous because you have to introduce facts also. And when you introduce facts, you be honest there, you be objective. Don't be subjective from when you are introducing facts in longer arguments. Because if you become objective, subjective from the very first sentence, again, you will lose the judge. You will not win it. And you should never forget that judge is not something which comes from different world. They are the same human being, just like we are. There is a man in judge, and you are arguing actually before a man who is sitting inside a judge. So you have to stir the emotion of that man. You have to win that man also. In order to win a judge, you have to win that man. You cannot separate man from the judge. So the man is vulnerable to all those impulses, although since they are professional judges, so they keep control onto that, but still you should not push them to a level where maybe they become a bit upset or you will start losing them. So facts have to be unbiased in manner. Then you come onto your argument, and then you can argue all those beautiful arguments which you must have prepared by that time. And that is how you can close your speech. And finally, with some beautiful sentences, some good judgments, some relevant paragraphs, keeping into mind that judge shouldn't become bored also because of your long argument. You try to keep it short and try to keep it crisp. And after that, when you submit your written submission, that will make all the work very easy. This is the basic art of advocacy, and if you stick with the basics, there is no other best strategy. With the limited practice which I have in these three jurisdictions, I can say that always stick with the basics, apply the basics rule, apply the basic fundamentals, and you will never be in a situation where you will find yourself any difficult about. So apply the basics, follow the basics, rule of pleading, basics, rule of evidence, basics inside the courtroom, humility, humble, respectful, and the art of advocacy. You can do little bit of experiment here and there, and you will get that opportunity during the course of argument. Suppose some judge become curious on certain point, you can always show your art at that particular point. I can remind myself about my one experience. I was doing a matter between different hedge fund, many hedge fund companies are my clients. So it was a case between one hedge fund company and their partners. They were fighting for some money. And that hedge fund, I won't take name because it's a confidential issue. They were one of the renowned in the world. I was the part of team. And on that given point, I was leading my submissions. The hedge fund companies these days, they don't do calculations by human. There are supercomputers which do calculations. And believe me, those computers are so accurate that they also keep into account the human behavior. How much pressure I can face, what I will react if I am given certain information. And that is what this media, the social media, is actually playing on the mindset of people. Or one kind of hashtag trend can shift entire mass in one direction. Another kind of hashtag can rise the share value of market. So that is how all understood by those lovely computers kept into those big hedge fund companies. It is based upon a game theory. The game theory, the chaos theory, these all theories are imported therein. So during that course of argument, suddenly just become curious and ask me that, can you please explain a little bit on game theory? And it took more than 30-35 minutes in explaining how game theory and how the theory of John Nash, the Nobel laureate economist, has paved the way where these computers are taking all those chaotic human behavior into account, and they are trying to postulate something out of that. They can predict something out of that. So while doing all that, you need to be very clear on your professional conduct also. That is very respectful and very attentive. Having knowledge is always good. My friend Sharmaji told you about that. You need to learn every day. And finally, you should never forget that your overriding duty is towards judge. Your overriding duty is not towards your client. There are two overriding duties which are the most sacred duties of lawyer. There are two. The first is your duty towards judge, that is court, which is overriding in this world. And second, the confidentiality to your client. So even when there is a conflict between overriding duty towards court and confidentiality to client, there is a provision that you can escape from the case, you can return the brief, and you can request judge to discharge you from a case. But you cannot be compelled ever to breach the confidentiality, and you should never think of breaching your overriding duty towards court. So when you are doing a matter, you are an officer of the court. Your client's duty comes later. Your duty towards judge comes first, but your duty towards client insofar as confidentiality is concerned is inviolable. When you find yourself ever in conflict with your duty with client and duty with judge, you should cease to act in that case. Withdraw yourself. That the ethics says. And then there are honesty, integrity, that always everybody has to take into account. You should not charge more, and you should always abide by integrity and all that. So these are the basic nuances. And that's with all this, I would like to confine myself today. Maybe if I can take some of the questions of my friends, I'm always available there. Yeah.
Thank you, sir, for sharing the knowledge and art required for the advocacy. With your permission, can we start with the question answer round, as there are a few questions we have received from the participants related to this session?
Sure, my pleasure.
So the first question is, what to do when you're stuck in a question of law which is asked by the judges?
See, I personally feel that there is no other best defense than being humble and be acceptable. You should accept that you are lacking certain things. You can very politely request, my lord, grant me some accommodation in terms of time. I'll come back to you after maybe, or pass it over, or maybe grant a short adjournment. So if you are genuinely caught into a certain situation which was not actually created by you, then the judge will definitely perceive it, and they will be very generously grant you time. After all, these judges are the same human being, and they have been from us only. So they understand. Many a time it happens. Even the bigger lawyers, the senior advocates, they also get stuck. And they very politely they take time, and judges very generously grant them time, provided it is not created by somebody's out of some kind of design. Because then they will find out, and then they will come very happily.
So the most asked question is regarding the legal leading questions, is how to frame only leading questions in your cross-examination, which could lead and bolster their testimony to your argument.
See, when you are, as I would repeat again those three words, when you are doing cross-examination, your duty is to put your case to the witness, not much bother about the answer of the witness. Because if the witness is very strong, professional and robust kind of, fully prepared and adamant not to speak truth, you cannot break. There are professional kind of witnesses who are very difficult to break inside court. You put up your case, give all the facts to them. You did this, this happened, you have seen that, you were on that day on the road, you have seen the vehicle was coming in a very high speed. If it is driver, you were not driving well, you were in a very high speed, you were casual, you have not looked that there is an old person walking on the street. So that is how you put your all leading questions to that. You were there at 4 p.m. You were there with the stick. You hit that stick. You hit the person with the stick. You hit on the head. Obviously, he will say, no, 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 no. I am the most honest person. I have never been. Maybe he will see that I was in England at that time. But doesn't matter. You have to put up your case. And then the questions which you are putting while putting up your case shouldn't be frivolous. You be careful that what you are putting up, later on you can substantiate it with some neutral facts. And now, even though you don't have a very credible fact to support a story, there will be circumstances available there. Circumstances speaks louder than evidences, louder than any facts. So that you can construct circumstances by way of those questions. If you practice it several times, you make one of your friend witness, and you practice the art of cross-examination and examination in chief. It is the sheer act of practice. 99% is preparation. If you read the same witness statement and try to find out questions where you can hit that person, you can contradict that person with the facts on record, you can do that. That's a very simple thing. And it's a human behavior that you are learning in your law school every day. Your learned professors are there to guide you on each of these points. Thank you.
So the next question is regarding the witnesses, as what to do when the memory of the witness cannot be refreshed.
See, it happens almost every time, because the incident is of 5 years, 10 years ago, and then you are putting a witness. You can't expect them to remember everything with all precision. And that is why law is a law of life. It is a subject which learns a human behavior. Judges gives that much of credit. They don't expect that you come and enumerate everything. You give all the details, digits. No, all that they try to see that is that person confident? Is he on? There are certain core of the case. Is he intact on the core? Is it not running away from the core theory of his case? So long core theory is intact, you will get marks from the judges. But you have always procedure to refresh memory of your witness. There is a certain procedure, certain questions that you have to go through it. For example, suppose somebody missed that, some incident was done by 10%. And suddenly, and the person has given this statement in witness statement before police that it was 10%. Later on said about 12 to 15%. He got confused. It's a 5-6 year. Now you can stop there. You can ask that, have you ever given a statement in this regard before police? आप इंडिया में है, 600 से हिंदी में पूछ सकते हैं, कभी दिया है स्टेटमेंट पुलिस के साथ दिया है, कुछ याद है कितने लोग थे, बताया है, नहीं सर याद नहीं आ रहा है. अगर कुछ याद दिलाया जाए तो याद आ जाएगी, हाँ याद आ जाएगी. याद है उस समय किसने स्टेटमेंट लिया था, कहाँ पे स्टेटमेंट हुई थी, हाँ हुई थी. इस केस के बारे में थाना पे गए थे, हाँ गए थे. वहां पे एक विटनेस स्टेटमेंट लिख के दिया था या पुलिस वाले ने नोट किया था, पुलिस वाले ने नोट किया था. और उसके बाद तुम्हें पढ़ के सुनाया था, हाँ पढ़ के सुनाया था. So if I can show you today that statement, would you be able to recognize it? Yes, sir, I will be able to recognize it. Then you can take permission from judge. So in order that you can refresh memory of your witness, you need to establish a couple of things before judge. The first is that he was actually the person who gave earlier statement. He is not lying to the extent that the statement was given. His statement was actually recorded. His statement was part of charge sheet. His statement was actually relied upon by prosecution or defense, vice versa. And that is why, and he is truthful to the core theory of the case. He only what missing is some number which an ordinary person can miss. If you are able to explain this by way of those few questions to your witness, judge will allow you to refresh the memory of your witness. So this is a procedure that can be done. Yeah.
So the last question is that what weightage does opening and closing statement hold, and the importance which could also decide fate of your case, and also tell us how to frame those opening and closing statements.
Preparation, preparation, preparation. 99.9% preparation. There is always a simpler and better way of presenting yourself. You can always explain yourself in most easy, most lucid English. Try to practice the English which even a 6th class boy can understand. If you plead a plaint, if you draft a plaint, and that can be understood by a class 6th and class 7th boy with accurate facts, and can tell you that, okay, this is what you have written, you are done. Many a times we try to use tongue twisters and we complicate the things. Don't do that. Make it very simple, smooth. And that will come only through preparation. There is no other way. Prepare the same witness statement 10 times. You will always find something new on the next time. So that is the key. And that will come by a regular course of practice. Always, we all know that learning is incremental. Fortunately, you all are in such a brilliant law college, which has been now renowned globally. So you have a facility of honing all your skills with such a great scholars who are available readily. So this is the time, use it, talk to them, discuss with them. That's the best way. I have worked with few students from ICFI, and they are really gem. Akshay Srivastava was my junior. Shubham Saket was from ICFI. I can take name of Manish Thakur. They all are so good students. I found them so brilliantly trained that they are doing very good from very next day when they came in Delhi. I relied upon them. They handled matter from district court to Supreme Court on the very next weeks. So fortunately, you all are in very good place. Yeah.
Thank you, sir. Thank you so much for your time and knowledge, which you have imparted to our participants. Now over to you, Sunil, sir.
Thank you, everyone. Thank you. Thank you, sir.
Definitely, sir. We are very privileged to have you here, though it was for the second time that I have this opportunity of listening you, and it was your lecture was, sir, so coherent, and it was your each and every line, every word was so important that it seems to be that time passes in just a jiffy.
Thank you, sir.
So
thank you so much. You are very generous.
Just, it was due to COVID times that we are interacting in such a manner. Otherwise, sir, it is really pleasure to listen you face to face, because I remember in your last lecture at auditorium at ICFI University, you have just discussed the 3 phases of life of the lawyer. I still remember your words. It was so interesting. You have just explained how a lawyer has 3 phases in the life. In first phase, he has to struggle. Then like this, you have mentioned all those. So definitely, I'm sure that my student would have been benefited by this lectures, by your advices, by your different experiences that you have shared. And really, sir, I am very thankful to you for to be here with us. And being a scholar of law, I can say that with this today's lecture, I have also learned so many things from you. And with this, we have one of our very hardworking professors, Miss Monica Khrola ma'am with us, who has been uh, constantly inspiring us and have been with us with this organization for the last so many years, and was instrumental from bringing this ICFI University to this day. So over to you, Monica ma'am, to give the vote of thanks.
Thank you, Sunil. And it's always a pleasure to talk at the end of the workshop or the event. And I'm really thankful to our two speakers, Mr. Vivek Narayan Sharma, and of course, Mr. Kundan Mishra, who has very effectively delivered his uh, art of advocacy. And I'm sure that the students have learned from his experience, which he has had over these years in different countries, including India, UK, and Seychelles. So it's been wonderful, and I know how important it is for lawyers to have those good advocacy skills. And having practiced myself in the district court and the high courts, when we counsel our students, we always tell them that they should practice in the lower courts in order to understand the basic nuances of advocacy, which is important and is handy when they are dealing with the cases even in the higher courts. So Mr. Kundan Mishra, he's been a wonderful guide. He's always been associated with ICFI University and has always helped us in giving internships and even placement to our students. And his experience has been tremendous. And we always look forward to times when he could come to the university. And I'm sure that Sunil sir himself would love to invite him for discussions on, evidence, or while giving classes on Indian Penal Code or CRPC. So these are learning processes, and for a student, even small things which the advocates who have today made it a part of their excellent career, and they have done so well that today the Supreme Court judges are saying that good lawyers do not easily accept even the High Court judgeship. So that is what is the greatness of practicing. And the sky is the limit if students want to do well in litigation. And it's a great field to be very challenging and very effective in giving remedy to clients. So the ethical and hard work that our advocates do go a long way, not only in giving them remedy, but also helping the court to come to to deliver correct justice and to give justice in time. So advocates play an important role. We are thankful to Mr. Sunil Kumar, who has brought this program to the students. And on behalf of ICFI University, Dehradun, I again thank the two speakers, Mr. Vivek Narayan Sharma and Mr. Kundan Mishra, for being with us in these difficult times, and for always having that enthusiasm to share with the students their knowledge and to inspire them to become good lawyers. So thank you once again, and to Sunil and his team of students who have worked hard to conduct this event. Thank you on behalf of ICFI Law School. Thank you to Dean sir, and for the support to Vice Chancellor sir, who has always been with us in our programs. Thank you to all. Thank you to all the participants for being here and for learning things and then imbibing them in your studies, imbibing them in your practice, and using them when you become advocates. They'll come handy to you. All the best. Take care and be safe. Thank you to everyone. Thank you. Over to you.
Thank you, ma'am. Thank you so much for your kind words. Now, thank you everyone, all the participants, dignitaries, and our faculties for making this workshop a successful one. Over to you, Sunil sir.
Okay, I would like to speak only two sentences. One that
Yes,
is
sir. Yes, sir. Yes, sir. Sure.
the type of knowledge which was provided by our two great speakers, keynote speakers, Mr. Vivek Sharma ji and Kundan Mishra ji. They are really very informative, very encouraging, and very systematic and very comprehensive as far as the art of advocacy and nuance of trial advocacy is concerned. So, both of them have spared their valuable time for our students here in this university. So we are very much thankful to both of them with folded hand. And next time, sir, we hope to meet you here in this ICFI campus. So that face to face, you can have interaction with the students, you can encourage them, you can teach them, and you can very comprehensively tell them what to do and what not to do. In fact, sir, your lecture was so interesting that I cannot tell you. I have heard only a few lectures only of this time. They were relating to each other. Every link was there. All these things were linked together, very systematically and linked. So I'm very much thankful to you, sir. Thank you, sir. Sir, Sunil sir, now.
Thank you, sir.
आपकी आवाज नहीं आ रही Sunil sir मुझे तो.
Sir, I think now I am audible.
हाँ, now you are audible. मुझे नहीं आ रही थी.
Okay, thank you, sir. Thank you for such a nice words and the true words for the speaker. And with this, I thank all my teammates, right from students of first year to fifth year, especially to Shruti, Mirnal, to Ria Tanwar, and all those who are instrumental in organizing this event successfully. And sir, we will really be looking forward in future that we are inviting you as just Monica ma'am just asserted very aptly that definitely we would be highly privileged if you would be here sometimes when this COVID is off, and we will always be very happy if whenever you have a time, you can share your views, you can guide our students, because in fact these students, these budding lawyers who are here on the platform pan India, hundreds of budding lawyers are here, those who are listening to you, and definitely many of them have motivated and will go on your way. One thing which I last but not the least important about many of as while the profile was read, many very few people know that sir have left judiciary for the sake of practice, and today he is at the helm of the affairs. And as Monica ma'am very rightly said that sky is the limit. Sir, you have set an example that this profession of advocacy has always shine like everything. And I will request, I will just advise all of my pupils here on the platform and those who will be just having listening there somewhere on the YouTube, that please don't feel discouraged, because many of you are moving towards LPUs and all those sectors just for the easy money, or you are going for the judicial services examination or other examinations. I assure you that being an advocate will definitely, though, because sir ke paas aaj time come tha, otherwise he would have elaborated that those phases, and definitely you would have also motivated by those in his next lecture. Definitely we will arrange it very soon. Definitely he would motivate our students to adopt this noble profession of advocacy. So with this, by your permission, Dean sir and Monica ma'am and Kundan sir, so we